Okay, thank you. I think we make a start at that point. So again, you're very welcome this afternoon, and thank you for joining us. This event is part of our consultation on our burial and cremation project. Just to sort of quickly explain the format we're using, that this is a Teams meeting. During it, as it's a public event, we have sort of taken the now usual precautions, and that your cameras and microphones are not working. So you can see us, and hopefully you can hear us, but we can't see or hear you. The way for you to correspond with us is through the Q&A function, which hopefully you will see on your screen. So not the chat function, but the Q&A function. I would encourage you to post your questions and comments on that. They will come to us to be moderated and then published. And the moderation there is purely just as a common safeguard. So I'm Nick Hopkins. I'm the Commissioner leading our work on burial and cremation, and joining me from the Law Commission team is Andrew Baisley, the lead lawyer on the project. Andrew will be talking to you during this event as well, along with Abby Rowett, who is one of the project research assistants, and our other research assistant, Guy Gabriel, is also on the call. If you're not familiar with the Law Commission, we are an independent body. We're established back in 1965, and the task we were given is to keep the law of England and Wales under review and make recommendations to government for reform. So we are an organisation called an arm's length body, which means that we are funded by central government and only by central government, but we work independently from government. The meeting this afternoon is one of a series that we've held both in person and online to support our burial and cremation work, and they are incredibly useful for us to get your initial thoughts on the provisional proposals we've put forward. And we hope they are useful to you to give you the information that you need to put in a written response to our consultation. And we really hope you will be prompted to put in a written response, as we will be analysing those in order to come up with our final recommendations for reform. We're really pleased to be joined by so many people this afternoon, and we know that you'll be approaching the topic from different perspectives. For some of you, the topics we're discussing are part and parcel of your jobs, whether sort of working in the sector or as researchers in the area. But there may also be people who have joined because of a personal experience you've had with the current law, and if that experience has prompted you to join that event, then it may well be that that experience was a very difficult one. And we understand that the issues we're discussing do have emotional resonance and are issues that can cause a degree of anxiety. We've been struck by the fact that a lot of conversations that happen within the sector aren't really part of more general discourse, and topics that are familiar to those who work in the sector are very unfamiliar and sometimes unsettling to those who don't. And I'm sure that we'll all be aware of that in any sort of comments and questions that we post today. So in terms of the content of the event, it's essentially divided into three parts. So I'm going to say a little bit about the scope of our work, and then address one of the key issues we look at in our consultation paper, which is the topic of grave reclamation and grave reuse. Abby is then going to talk to you about the law on closure and reopening of burial grounds. That will end the first part, and we'll pause for questions and comments. In the second part, we look at reform to the law of regulation of burial grounds, including exhumation and the law on disused burial grounds. We then pause again for questions and comments. And then the third and final section will focus on cremation law with a final opportunity for questions and comments at the end. So beginning then with the scope of the project and how it fits into a wider piece of work the Law Commission is doing. It's a piece of work that we started right at the end of 2022 with the scoping phase. And given the very wide range of issues that were being raised with us at that time, we agreed with the Ministry of Justice that the best way forward was to divide the project into three parts. And so this first part is looking at the law around burial and cremation. A second part is looking at putting in place a system of legal regulation for new funerary methods. So that's looking in particular at alkaline hydrolysis and human composting, but is looking more generally at putting in place a future-proof form of regulation to determine which new method should be permitted. That work is already underway and will reach its consultation stage next year. That piece of work has been led by my colleague, Professor Alison Young. The third piece of work, which this team will commence at the end of this project, will look at rights and obligations in relation to funerals, funerary methods and remains. And so that piece of work will start at the end of next year. There are some issues that we know are significant, but which are outside of the scope of the work that we are doing. They include sort of death registration and a coroner system, the regulation of funeral directors, planning and environmental law, apart from one aspect of planning law that we will address in this event in relation to crematoria, and the preservation and embalming of bodies and the regulation of cryogenics. So all of the work the Law Commission does tend to move through three distinct phases. We have a pre-consultation stage in which we talk to sort of individuals and groups who we know have a particular interest in the area. Those initial discussions inform what we say in our consultation paper. We then have our full public consultation, which is the stage we're at now. And it's the responses we have to that consultation, along with all the other evidence given to us, that we use as a basis of our final recommendations for reform. But I should say that everything we publish, so the consultation paper we have now and our final report and recommendations are not just the work of the project team, but they reflect the agreed views of the 5 law commissioners. So I'm going to turn now then to the first substantive topic, that of grave reuse and reclamation. So to some of you here today, these will be familiar issues and terms, but to others they may be less familiar. So when we talk about grave reuse, we mean disinterring remains from a grave, reburying those remains and using the whole of that grave again. When we talk about grave reclamation, we mean using additional space in a grave above an existing burial, leaving the remains from that existing burial undisturbed. So I'm going to talk first about grave reclamation and outline the current position. So if there are no exclusive burial rights over a grave, there's nothing in law to stop a burial ground operator from reclaiming that grave. But where an exclusive burial right exists, the position is different. An exclusive burial right is a right that's been bought by someone, which gives them the right to decide who is buried in the grave. So commonly bought, for example, by a couple or a family to enable them to be buried in the same plot when they die. In the past, these are often granted to people in perpetuity, or in other words, forever. Nowadays, they are more usually granted for a long but fixed period of time, say 50 or 75 years. Where an exclusive burial right exists, the grave can only be reclaimed if that right is first of all extinguished or brought to an end. And at the moment, only London local authorities and 3 burial ground operators with their own private Act of Parliament have the power to extinguish burial rights. So in practice, the ability to reclaim a grave where an exclusive burial right exists is confined to those burial grounds. And also in practice, when we talk about extending the ability to reclaim graves, what we're really talking about is extending the ability to extinguish existing exclusive burial rights. And that's particularly relevant where those rights have been issued in the past in perpetuity. Where the power to extinguish burial rights exists at the moment, it can't be exercised until at least 75 years after the last burial was made in the grave. And in order to use it, the burial ground operator must put up notices of their plans in newspapers by the entrance of the cemetery and must send them to the registered owner of the grave. In those cemeteries with their own Act of Parliament, they also have to post the notices online and by the grave itself. If the owner of the right objects, then the burial right will not be extinguished. If anyone else objects, it will only be extinguished if the Secretary of State gives consent. So that's the current position in relation to grave reclamation. I'll outline now the current position in relation to grave reuse. So grave reuse has been permitted in Church of England churchyards and burial grounds since time immemorial, with a faculty required if more than minimal remains are moved or if memorials are affected. A faculty is an order obtained by an application to the Church of England's own courts. The application is made to the ecclesiastical court within the diocese, which is known as a consistory court. We don't make any proposals to reform the system of decisions by the consistory courts or in respect of grave reuse by the Church of England. Other than the Church of England, the same group of burial ground operators who have the power to extinguish burial rights also have the power to reuse old graves. So in other words, London local authorities and those 3 that have their own private act. If there are any exclusive burial rights in place over the grave, the burial ground operator will first of all have to extinguish those rights using the process that I've just outlined. Once they have been extinguished, or indeed if none have been granted, the burial ground operator then moves on to a second stage. Onto this second stage, they have to follow another process. It's very similar to the one used to extinguish burial rights. So again, 75 years must have passed since the last burial, and notices must be issued before the grave reuse takes place. In relation to grave reuse, an objection by either the owner of the burial right or certain relatives of the person interred in that grave will stop the process. And such an objection means that no further attempt to reuse a grave can be made for another 25 years from the date of the notice. For London local authorities, any remains found in the grave during reuse must be reburied in the same grave using a process referred to as lift and deepen. For those cemeteries that have their own private acts, they can remove the remains and rebury them somewhere else, but in the same cemetery. And that's a process we refer to as lift and rebury. So why then are we consulting on extending powers to reclaim and reuse old graves? And I can talk about reuse and reclamation together here as the same considerations apply. There is evidence from a number of surveys to suggest that we are running out of burial space. So a 2007 survey conducted by the Ministry of Justice of 9,000 burial grounds suggested that the median predicted time before those burial grounds were full was 30 years, with a lower median time in some urban areas. And the discussions we've had with burial ground operators have presented a similar picture to us. They are concerned that they are running out of space and reaching the limits of their capacity. We know the cost of burials is also rising, and while the shortage of burial space is not the sole factor in that by any means, it has been suggested that it has an impact. And we also know that for followers of some faiths, including Muslims, many Jewish people, and Baha'is, burial is the only option that aligns with their religious beliefs, and so these risks are all the more concerning. New burial grounds could be built to address the risk of running out of space, but that's expensive to local authorities and other burial ground operators. And also, if land is being used as a burial ground, it can't, of course, be used for another purpose, whether that's to build houses or for uses that might generate new jobs. Reusing and reclaiming old graves would also enable existing cemeteries to continue to be used for burials and so continue to be active spaces of mourning. And we know that once a burial ground is no longer being used, there's a risk that it falls into disrepair and becomes a site of antisocial behaviour. But we also know that reuse and reclamation of old graves is a sensitive issue. Particular concerns may arise in areas where the population is less mobile and where the graves of ancestors may be visited many generations down the line. And so we think it's important that if these powers are going to be extended, that must be done with sufficient safeguards to ensure that where graves are reclaimed or reused, it has public support. And so the provisional proposals we've put forward contain two levels of safeguards. Now, most of our proposals apply to grave reclamation and reuse, but there are additional issues that apply to reuse, and so I'll describe our proposals in that context and then highlight how grave reclamation differs. So under our provisional proposals, in order for a burial ground operator to obtain grave reuse powers, they would first of all have to conduct a local consultation and submit the results of that along with a grave reuse plan to the Secretary of State for approval. The plan was set out which graves would be affected and any mitigation the operator intends to take following consultation. If approval is given, then they would move on to a second level of safeguards, and these safeguards apply to each individual grave. A key safeguard is that a minimum period of time will have to have passed since the last burial in the grave before the grave can be reused. And we ask what that minimum period of time should be. We think there are two key considerations here. One is the time it takes for human remains to decompose, and the other is the time required to pass so that a grave isn't reused during the lifetime of people who knew the deceased person. So on the first point, the time taken for human remains to decompose, we ask whether there should be a general requirement that a grave cannot be reused if it still contains significant remains from a previous burial. On the second point, the time that must have passed since the last interment in the grave, we ask whether that should be 75 years, so the time that applies where grave reuse is currently permitted, or whether, given developments in longevity since that period was set, whether 75 years is no longer sufficient and it should be 100 years or some other period. In either case, our scheme would retain the effect of an objection, in other words, that the grave could not be reused and no further attempt could be made for another 25 years. We make some other provisional proposals about grave reuse. This includes permitting both the lift and deepen and lift and rebury methods to be used by all burial ground operators to give flexibility. We make provisional proposals about the record keeping that would be required. And we also propose that burial ground operators should have to disclose that a grave has been reused if it's selling further rights over that grave. So those provisional proposals that apply to grave reuse would generally also apply to grave reclamation. So the same level of safeguards would have to be followed. But the provisional proposals as to which method of grave reuse is permitted don't apply, as they're specific to that process, nor do we have to consider the issue around whether significant remains are still in the grave, because they would not be disturbed if they are. So overall, our aim with this approach, including with the 2 levels of safeguards, is to enable the reuse and reclamation of old graves in a way that carries general public support, in particular that carries the support of the community around that burial ground, and which respects any objections by the family of deceased people who were buried in that grave in the past. So at that point, I'm going to hand over to Abby, who's going to talk about closed burial grounds.
Thanks, Nick. So, legislation has been in place since the mid-19th century to allow for the full or partial closure of burial grounds. This legislation arose from fears of epidemics being caused by overfull graveyards in urban areas. Nowadays, however, this legislation is predominantly used for administrative purposes to close full Church of England churchyards. It remains available to government, however, as a potential enforcement mechanism, for example, where there is a public health risk from a burial ground. The key provisions controlling these closures are still in place today. So, under the Burial Act 1853, an order in council is needed to discontinue burials in all or part of a burial ground, or to stop burials in a city, town, or any other area. An order in council is a form of secondary legislation authorised by the monarch upon advice from members of the Privy Council. The effect of a closure order is to criminalise further burials, and if the burial ground is a Church of England churchyard, to extinguish the church's legal duty to bury parishioners in it. There's no provision in place to allow for a closure order to be revoked. In our analysis, there are 3 main problems with the law concerning burial ground closure. First is the need to wait for a meeting of the Privy Council, which only occurs about once a month, which adds unnecessary and potentially substantial delay to what is most commonly a simple administrative decision. Second is the use of an order in council for administrative purposes is out of keeping with their modern legislative and constitutional usage, adding unnecessary complexity to the law. And third, there's also currently no way to reopen a closed burial ground. When the legislation was framed 170 years ago, this doesn't seem to have been a consideration. It is worth noting the recent case where His Majesty King Charles III intervened directly to help a mother bury her child in a closed churchyard which had emotional significance to the child and his family. This suggests that there may be many families and communities across the country who are unable to make burials in churchyards that have strong emotional resonance for them due to the absence of reopening provisions. Indeed, we've already heard that there is an appetite to open up more burial grounds for this reason. A further benefit would be that it expands the amount of available space, which is an issue that Nick has already set out. Therefore, we provisionally propose that the power to close burial grounds to new interments should be transferred to the Secretary of State, and the Secretary of State should have the power to reopen burial grounds in full with the agreement of the burial ground owner or incumbent. Finally, I'd like to address the issue of maintenance of closed burial grounds. So where a closure order closes a Church of England burial ground, the responsible parochial church council, the executive committee for the church parish, has the right to transfer maintenance responsibilities to the secular parish council or parish meeting, who can then transfer it up to the district council or equivalent. So the maintenance responsibilities and the related costs transfer from the Church of England to the local authority. We don't intend to alter this right. Every person has a right to be buried in their local Church of England parish church, which is known as the ordinary right of burial. This isn't to be confused with the exclusive burial rights that Nick has already set out. This right is part of the Church of England's status as the established church in England. The ordinary burial right means that the church conducts burials, responsibility for which might otherwise fall on local authorities, and therefore justifies the right to transfer maintenance. But if we take a closed burial ground which has had responsibility for its maintenance transferred in this way, if it's then reopened, who should be responsible for maintaining it? Should it transfer back to the Church of England, or should it stay with the parish or district council? We provisionally propose that maintenance responsibilities for reopened church burial grounds should remain with any local authority to whom they've been transferred. We consider that it would act as too much of a deterrent to churches to reopen burial grounds otherwise, but we recognise that returning the burial ground to use could increase the financial burden on local authorities. We are therefore asking consultees whether Church of England fees for funerals and burial should be shared with local authorities, or whether an additional fee should be payable to local authorities. Finally, although the Church in Wales is under a similar duty to bury parishioners as the Church of England, it has no equivalent power to transfer maintenance responsibility for closed burial grounds to the local authority. We therefore consult on whether the Church in Wales should, like the Church of England, be allowed to transfer the responsibility for maintaining its burial grounds to the local authority. We recognise that this would create a significant cost pressure on Welsh county councils, which are already under financial constraints. However, the arguments against removing the duty on the Church in Wales to bury parishioners are too strong for it to be worth consulting on as an option. Removing the duty would mean that people in Wales, unlike those in England, would have no explicit right to be buried anywhere. I'm now going to stop there and hand back to Nick and Andrew for our first Q&A session.
Thanks very much, Abby. So we have one question from Ian Hussain. He asked, do you consider proposing that cemetery operators be given flexibility in setting the time passed since the last burial, taking account of feedback from local consultation and allowing for local decision making? A minimum period would obviously need to be set, e.g. 50 years. There might be two aspects of that question. One is whether whatever minimum period is set, would a burial ground operator be able to reuse graves earlier than that minimum period? Might there be a process for that? And that is something that we discuss in the consultation paper. We're aware, for example, that some religious groups have burial ground which, because of the length of time they've been established for, would want to be able to reuse them in a shorter period of time, because otherwise any reuse powers are not practically going to be able to help them. So we do ask in the consultation paper that if there should be some provision enabling them to do so, and how that would operate. The other aspect that's worth emphasising is that whatever period is set, there would be no obligation for a burial ground operator to reuse graves. So a burial ground operator may not need to do so, or may simply choose not to do so, and there'd be no requirement for them to go through that process. So our provisional proposals are intended to be sort of facilitative rather than mandatory. Then a question from Tamara Galloway. The consultation paper states that the Office for National Statistics has confirmed that there are no centralised statistics on the proportion of people who are buried or cremated, and that for burial, sources such as ad hoc surveys or that is available. In addition, the cemetery is an acceptable green belt use. So why do you think grey space will run out? We are relying on surveys that have been conducted. So I refer to the Ministry of Justice survey from 2007, and there have been a couple of surveys since, including I think from the BBC, which paint a similar picture, and that's a picture that has also been painted by the burial ground operators that we have spoken to. So, no, as you say, and as our consultation paper acknowledges, there aren't the clear statistics that ideally would be available, but the evidence we have does suggest that there is the pressure on space, and indeed we know that those burial ground operators that do have the powers are using those powers because they are running out of space, and if they can't reuse or reclaim graves, and they will have to look towards acquiring new land. And then a question that's just come in from Martin. You have not mentioned any proposal concerning non-conformist burial grounds, both in use and disuse. What are your comments on this aspect, please? So in general, burial grounds fall into three categories. There are those operated by the Church of England, those by local authorities, and then all others. And all others we refer to broadly as private burial grounds, albeit some of those are owned and operated by religions, and some of those are owned and operated but by other groups. And so generally, our provisional proposals on grave reuse and reclamation would apply to local authority and or private burial grounds, so not those in the Church of England. And I skipped over a question there, sorry, from Philip Pritchard. David, you use the term significant remains. Can you clarify what you mean by significant? Also, are people living longer? Have you considered increasing exclusive rights to perhaps 125 years? So in terms of significant remains, that is a term that's used in the current law, and we do consult on how it might be interpreted. So we'd be very keen to hear your views on that. Have we considered increasing exclusive rights to perhaps 125 years? The trend really seems to be in the other direction, of exclusive burial rights being granted for a shorter period than that. For private burial ground operators, it would be a matter for them to decide how long they want a right to be granted for. I think I've covered those there. Andrew may want to add or supplement to anything I've said, so I'll hand over to him.
Thank you. There's one further question which has just come in from Lindsay Mace, who asks about the different processes that have to be followed regarding extinguishing a right and applying to reuse a grave. She says that the consultation paper says the same safeguards would be applied to public graves as to those with exclusive burial rights, but she's unclear if that means that before a grave is reclaimed, there would need to be any notification in the case of a public grave. So I would separate here between grave reclamation and grave reuse. The only barrier to grave reclamation in all cases really is the existence of any exclusive burial rights which control what happens to that grave. So that already is the case and already applies to grave reclamation across all different types of burial grounds. And we don't propose to change that. So if it's a common grave, reclamation is already possible without notification. In terms of grave reuse, so that is, if the remains are to be removed from the grave and either buried deeper or elsewhere in the burial ground, then that's where we're saying that the same safeguards would apply to public or common graves, as well as to those which have exclusive burial rights or had them, because they would have had to have been extinguished in order to then reuse the grave. So we sort of can't apply that additional safeguard to common or public graves in terms of reclamation, because it solely relates to there being a burial right in place already.
Thanks, Andrew. And just seen another question from Darren Gregory, who asks, why can't local authorities simply return closed churchyards to the Church of England so they have to maintain them, or any costs incurred can then be invoiced to the Church of England? I mean, at the moment, the costs do go to the local authority, and we don't sort of suggest changing that position. It recognises that because the Church of England has a duty to bury parishioners, as Abby indicated, the Church of England is sort of picking up costs that might otherwise fall on the local authority in that respect. And I should add, the Church in Wales has the same duty, but the cost of maintaining any closed burial grounds don't currently go to the local authority. So the position we ask about is what should happen if those burial grounds are reopened, as to whether at that point some of the money that is paid to the Church of England could be paid to the local authority to cover the costs. We don't propose that the full cost is returned to the Church of England, largely because we feel that that would probably be a disincentive for the Church of England to reopen those burial grounds, but would be very keen to hear your views on that in consultation. And another question from Ian Hussain. Will you consider a requirement for cemetery operators to make financial provision for future maintenance responsibilities using income received for rights granted for such long periods, particularly important that private cemeteries start to reuse on a scale? We haven't made proposals along those lines. Again, we'd be happy to hear from you about it in consultation. I mean, certainly some of the burial ground operators we have spoken to, they do have in mind their future maintenance costs at the time that the cemetery is full, and so the income is no longer being received. And Andrew will have more to say about maintenance in the next part of the talk. And another question from Martin: what would be the position in regard to headstones and memorials in place over graves that are reused or reclaimed? That is a really good question, as it's something we've heard a lot about during the consultation. Under the current law, where graves are reused, there is an opportunity for the family to take the memorial back, and otherwise it is left to the cemetery operator to do with as they wish. And practice varies. Sometimes they are kept in the cemetery, either resting up against a wall or back to back on the grave, but sometimes they are simply destroyed. We know there is a lot of sort of interest and concern around, in particular, capturing the full memorial that's on a gravestone, and that's something we're sort of keen to explore during the course of the consultation. So any views you have on that, we would really like to hear. I think those are all of the questions at the moment, so I will hand over to Andrew for the next part of the event.
Thank you very much, Nick. So in this section, I'm going to talk about the regulation of burial grounds, including maintenance, the rules on how a body must be buried, burial rites and memorials, and record keeping. And then I'll talk about exhumation and disused burial grounds before we take a break for questions, and then talk about cremation law. So overall, the law governing burial has developed piecemeal since the 19th century in response to social changes and emerging public health concerns. The result is a patchwork of different laws. And Church of England churchyards are governed by the decisions of the Consistory Court, as well as some old Acts of Parliament and measures that affect the Church of England. Local authority cemeteries are governed mainly by the Local Government Act 1972 and orders made under it. The Church in Wales is governed by two particular acts. Some private burial grounds have their own private acts of Parliament which govern their operation, but for others there are few laws applying at all. When we talk about private burial grounds, as Nick has said, we cover a broad spectrum, anyone who's not the Anglican Church or local authority cemeteries. So that includes other religious burial grounds, private enterprises, many natural burial grounds, for example. Local authority cemeteries are currently the most closely regulated type of cemetery, and we've not generally heard that the governing legislation causes significant problems, although there are a couple of exceptions that I will note. We've heard calls in our pre-consultation discussions for the introduction of a uniform burial code, a set of laws that would apply in the same way to every different type of burial ground. But we think there are arguments against that approach. Different types of burial ground come from a different starting point and different historical contexts, and that includes the role of ecclesiastical law in Church of England churchyards, which reflects the Church of England's status as the established church. And moreover, different types of burial grounds serve different purposes. So private burial grounds of a religious character their rules will often reflect the religious nature of their establishment. So as a result, our focus has not been to look at a single uniform burial code, but to look at different specific aspects where more uniformity is justified or where greater regulation is justified than currently exists, and consider how those should apply to different types of burial ground. So firstly, I'll talk about the maintenance of burial grounds. There are different standards that apply on this for different types of cemeteries. And there are no laws governing maintenance at all in many private cemeteries if they weren't established by an Act of Parliament, which is primarily the sort of old Victorian cemeteries. Some stakeholders have noted that the lack of consistency on maintenance rules can cause confusion, but also we've heard that while poor practices are an exception where they do occur, the lack of any consistent standard of maintenance that's required by law can make it difficult for government to enforce. And that's why we provisionally propose that all of the different rules should be replaced by a single legal standard of maintenance that would apply to all burial grounds. We acknowledge that the standard needs to be flexible to accommodate the wide range of different burial grounds that it would encompass, for example, a closed non-conformist burial ground to a large currently operating private burial ground. That's why our provisional proposal is that every burial ground should be maintained in good order, appropriate to its current use. We've heard of some instances of poor maintenance, but not that there is a widespread problem. And so we therefore ask in our consultation whether there is evidence out there that this is a more widespread problem that ought to have further steps taken in order to address it. So the two steps that we particularly note could be taken are government publishing a code of practice for burial ground maintenance, or a requirement on all burial ground operators to publish a management plan for the cemetery. Next, I'll talk about how bodies should be buried. At present, there are only consistent laws on this point in local authority cemeteries. In no other type of burial ground is there a consistent set of rules on how deep a body should be buried, or the distance between burials in the same grave. In local authority cemeteries, the rule is that a body must be buried so that no part of the coffin is less than 3 feet below ground level. If the soil or shroud is made of perishable materials and if the shroud is made of or coffin is made of perishable materials and the soil is suitable, that it reduces to 2 feet. There must also be 6 inches of soil between burials made in the same grave, and there are separate provisions in relation to walled graves and vaults. We think there's a case for extending rules on how bodies should be buried to cover all types of burial ground. Improper burials can have a real harmful impact on families and friends if they result in remains being unearthed. The question is what those specifications should be. We think the main factor that needs to be taken into account is that need to protect against disturbance, usually by animals or other physical changes to the land. We think that the impact that depth of burial can have on decomposition of remains is also a concern, in particular in relation to natural burial grounds. The research seems to suggest that bodies buried deeper than 1 foot are less likely to be disturbed by animals, but stakeholders have told us that they think 3 is generally necessary. And then there's also differing evidence as to the depth required for faster decomposition of bodies, such as natural burial advocates tell us they value. Because the evidence points in different directions in this way, we ask an open question on what the appropriate minimum depth of burial ought to be. We also provisionally propose extending the rule requiring 6 inches of soil between burials and the rules on vaults on walled graves, and we propose making it a criminal offence to breach the eventual burial specifications. The reason being that the harm and the wrongfulness of such conduct, which we think means that it justifies a criminal offence being involved. The Secretary of State has, under the current law, powers dating from Victorian times to order ad hoc inspection of cemeteries. We provisionally propose retaining those in a modernised form, so that if the Secretary of State, if an inspection finds that the law is not being complied on, for example, on the maintenance duty or on burial specifications, they would be able to issue a notice, and enforcement mechanisms would then include a power to direct a local authority to take over those actions and charge the costs back to the burial ground owner, or indeed the closure of the burial ground. I'll now turn to talk about burial rights and record keeping. So we've heard of 2 main problems when it comes to burial rights. The first is that in private cemeteries which are not established by statute, there are no requirements in relation to how rights should be issued. This can leave individuals unclear as to exactly what it is that they've purchased. And so to address that problem, we provisionally propose that all burial grounds should be required to issue burial and memorial rights in writing, with the option of a civil penalty issued by the Secretary of State as a means of enforcing that. Secondly, we've heard of disputes about burial rights between family members. In our assessment, most of these centre on a scenario where one family member has purchased the exclusive burial right to the grave in which a deceased person is buried, and they then refuse to erect a memorial over the grave while other family members wish to. This, in our consideration, this causes distress to the family members and means that that individual isn't memorialised. To address this, we provisionally propose that in local authority cemeteries, the burial authority should have the power to grant a memorial right to any relative of the person buried in a grave, if none is erected within 2 years. If there's a dispute between family members as to what the memorial should say, or indeed whether it should be erected, then the memorial would be restricted to solely a neutral one, that is, with the name, date of birth and date of death of the individual. This proposal only relates to local authority cemeteries because it's only in those cemeteries that the person to whom a memorial right can be issued is governed by statute in this way. And I'll briefly touch on record keeping. So all burial grounds are subject to record keeping requirements, but the nature of the requirement varies. In many private burial grounds, it's governed by the Registration of Burials Act 1864, which simply works to extend the registration requirements which apply to the Church of England to all other burial grounds. And that's something of an awkward fit. It also means that not all burial grounds are legally required to keep the full suite of information that local authority cemeteries must keep, namely a burial register, register of disinterments, plan of the burial ground, and register of rights granted. While human error also plays a part, we consider that this lack of documentation may lie behind some cases of burials being made in the wrong plot, which results in unnecessary and distressing exhumations. So we provisionally propose introducing a uniform record-keeping requirement along the lines of that in place for local authorities, but this would not be retrospective, so we wouldn't be asking any burial grounds which have been making burials for hundreds of years to go back and map those, only to map and register those made in the future. Next, I'll turn to talk about exhumation and disused burial grounds. So the starting point for the law on exhumation is that it's a criminal offence to remove remains from any place of burial without authorisation. Authorisation being either a faculty from the consistory court if they're on land consecrated to the Church of England, there are separate rules for cathedrals, or a licence from the Ministry of Justice if they're not. We don't propose fundamentally changing that position, although we do propose minor amendments to the rule and an increase to the maximum criminal penalty. The main reform that we propose in this area, though, relates to disused burial grounds. The Disused Burial Grounds Act 1884 makes it unlawful to build on a disused burial ground, other than for the purposes of enlarging a church or another place of worship. A disused burial ground is simply one that's no longer used for interments. It doesn't have to have been formally closed in the way that Abby described earlier. But this rule renders land which has been used for burials sterile. As a result, there are a number of exceptions to it. Each of these also overrides the rule requiring a license or a faculty for an exhumation, so that multiple exhumations can be carried out at once in order to enable building to occur. Those exceptions apply to the Church of England churchyards and to other religious burial grounds. They don't apply to other private or local authority cemeteries. In the cases of Church of England churchyards and other religious burial grounds, there is a safeguard if a personal representative or a relative of a person buried in the burial ground in the last 50 years objects, the building cannot proceed. There's no such veto in relation to land which has been acquired for development, which is another set of exceptions that are also currently in the law. If there are no objections, then any remains in the burial ground have to be removed and either reinterred or cremated, and any memorials dealt with before building can take place. And similar to the position in relation to grave reuse, notices have to set out the plans. They also give families the right to deal with remains and memorials at the burial ground owner's expense. So the current law therefore leaves for private burial grounds and local authority cemeteries a lacuna. There is no provision enabling use of the land for any purpose other than burials in the future. And we provisionally propose that the scheme in place for other religious burial grounds, which includes that family veto, should be extended to these types of burial grounds. However, we consult on how long the period of that family veto should be. Should it be kept at 50 years, or should it be aligned to grave reuse at either 75, 100, or another period of time? We think there's a case that the 50-year period, just as is the case in relation to grave reuse, doesn't reflect an appropriate period of mourning. But we also recognise there are differences in relation to grave reuse. Exercising the veto only affects one grave, whereas in relation to disused burial grounds, it affects the whole scheme. Okay, I'll pause there and bring back Nick again for any further questions that we have from attendees.
Thank you, Andrew. There are a couple of questions that have come in, starting with Christopher Warman, sort of 3 down, if you want to go from there.
Thank you. So Christopher says that the minimum standard of maintenance could just refer to managed and maintained to the Green Flag Award standard. Potentially, I would like to hear more about that standard, but I think the sort of key issue here is that referring out to a standard which isn't a statutory one in relation to this would possibly be a bit of a potential shifting sand for the law. I mean, the existing laws on maintenance standards in burial ground have in some cases been in place for 150 years. It's a possibility that whatever we end up recommending in this case could be in place for a significant period as well, and it would be something that should stand alone. So that's it would be good to hear more about that standard, as there may be more to learn from it. So please do include that in your consultation response. But I think that we would want the standard that applied here to be one that stood on its own terms. Responding to the next one that Tina Naldra asks, would the new guidance around grave depth, etc., impact burials on private land? That's a good question. We do have a whole section in the consultation paper on burials in private land. In general, we don't seek to make any changes to the ability that people have to make burials on private land. We think that the burial specifications should apply to burials on private land, yes. And that's because the risks of sort of animal unearthing and so forth would still pertain to such burials. Obviously, there's a crossover between burials on private land and sort of natural burial advocacy, I think. So that's an issue that we are alive to and would want to hear from respondents on. Just to say on private land more generally, our main provisional proposal here is that the register that's kept of a burial on a private land would have to be transferred to the new owner of a property when any sale or long lease is made, just to ensure that there's that the risk is sort of inadvertent exhumation and or the purchase of a property without that knowledge is removed. Then Jude Griffiths has asked, doesn't allowing the burial authority the right to grant right of memorial erection to any relative after put the burial authority in the middle of family disputes. If more than one faction apply, how do you pick? So we're very live to the risk around family disputes, and that's why our provisional proposal is for the memorial to be neutral. We recognise that local authorities, I think, are potentially in the middle of these disputes already, but they at present they don't have the power to grant that right. Under our provisional proposals, they would have the power to grant the right, but it would just be for a neutral memorial. So it sort of steers towards a memorial being erected rather than the current situation, which steers towards one not being erected. We're aware of the sort of complexity in relation to burial rights and memorial rights. Our view on this, I think, is that the memorial rights are created by the current statute, are created by the current law. So amending the way that they can be issued through that law would be possible. But we do recognise the complexity on this point. Our provisional proposals do steer towards a memorial being erected being the kind of default option there.
Thanks, Andrew. There's a question I'll pick up from Tamara Galloway, who sort of highlights the interest in ordinary people's graves through sites such as Ancestry.com and more people finding out about their history through DNA. And she asks what we think about the increased role of graves in family history. It's certainly something that we are aware of and that has been raised with us in consultation, particularly around memorials at the point at which a grave is reused and reclaimed. I think it is quite a difficult one because we're certainly sort of sympathetic to the desire to sort of trace family histories and then sort of pay respects to ancestors. And I think the question for us is how to balance that with the sort of current needs there are around sort of grave space, and is there a way in which we can sort of satisfy everyone's sort of wishes and needs as much as possible. I suppose the difficulty is that if it's not feasible to leave all graves untouched because of the prospect that the family may trace them in the future, when for the vast majority of graves that probably isn't going to happen. So I guess the question then is how can we ensure that at least the records and the memorials are captured, even if the grave, for practical reasons, isn't able to be left in place. Now, obviously, finding a record is not the same as being able to visit a grave and sort of trace family members to their grave, and we're not suggesting that that's ever going to be seen as under par, but it's trying to balance all of these interests. And we're certainly be very keen to hear from you in consultation about what you think would and wouldn't be acceptable in that respect. And Martin has added a question following on from Tamara's, which and perhaps what I said is kind of echoing some of the points Martin is making as to whether where a grave is reused or reclaimed, more can be done to ensure that the headstone and memorial inscription are recorded in full, and that it is certainly something that has been raised with us, and something that we are keen to look at during the analysis of consultation responses. So again, please do write in with your thoughts. And a question from Lynn Cummings: can we have access to presentation slides, please? Yes, we will send the slide pack to you tomorrow. And I think I hand back to you, Andrew, for Eric Easton's question that's just come in.
Thank you, and then I'll move on to talk about cremation. So Eric asked if we considered the possibility of producing separate regulations for natural burial grounds, noting that remains in such burial grounds decompose faster, and that there are maybe different attachments to the individual graves rather than to the natural space that surrounds them. We haven't made any provisional proposals for separate regulations for natural burial grounds. I think there's potentially a difficulty in defining what constitutes a natural burial ground, given the variety and different practice in burial grounds. And we're also aware that, you know, for example, some local authorities operate parts of their burial grounds as what they term natural burial grounds, and therefore, you know, they're currently operating under the existing local authority framework. We're interested in hearing about sort of views from natural burial grounds as to if there are elements of our proposed scheme of regulation that would be particularly challenging for natural burial grounds. We hope that the flexibility, for example, in the maintenance standards would mean that they would be appropriate to the current operation of a burial ground as a natural burial ground. But yeah, we want to hear if there are particular concerns about how the current scheme would affect natural burial grounds. That's the approach that we've taken, rather than making a suggestion for separate regulation.
Thanks, Andrew. A question has just come in from Town Clerk, but I suggest we move on to cremation and then see if we can come back to that question at the end. Thank you.
Agreed. So cremation is governed by the Cremation Acts 1902 and 1952 and the Cremation England and Wales Regulations 2008. These have been frequently amended, and as a result, the law on cremation cannot be said, unlike the law on burial, to be generally out of date. Our provisional proposals therefore focus on addressing a number of specific long-standing problems which were raised with us during the pre-consultation period. Some haven't been addressed in law before, and one or two arise from the 1902 Act itself. I'll address these broadly in the order that they might arise in the cremation process, beginning with a body being transported to the crematorium, and then Abby will end with addressing issues that arise after the ashes have been collected. So the first of the issues that we address is that of mistaken cremation. This is where the wrong body is released from a hospital or funeral director's mortuary to the crematorium, where they are then cremated. This doesn't happen frequently. One study found 9 instances of it occurring between 2002 and 2013 in mortuaries within hospitals, but it causes understandable distress to two sets of families and friends, both of the person who was cremated and the person who was believed to have been at the ceremony that was held for them often. Mistaken burials along the same lines also occur, although without understating the distress that they cause, they are less completely irreversible because of the possibility of an exhumation should the families of those involved agree. In our assessment, there are already comprehensive measures to avoid the wrong body being released from hospital mortuaries through their regulation by the Human Tissue Authority. There's no such regulation for funeral directors, but that kind of regulation would be out of scope of our project. So we ask an open question of consultees as to whether there's more that could be done at the crematorium by crematorium staff to address this issue. Before a body can be cremated, an application for cremation must be made. We don't look in detail at the forms used for applications for cremation or the role of medical referees. Those are in a degree of flux due to the recent introduction of statutory medical examiners. However, we do look at the issue of who should be able to make an application. Currently, it must be the executor of the deceased person or a near relative aged 16 or over. However, an application can be made by any other person if the medical referee is satisfied that they are a proper person to do so, and of the reasons why no one in the other two categories has applied. The cremation form also then asks whether there are any near relatives or executors who have not been informed of the proposed cremation, and if they have expressed any objections. Lying on this form is a criminal offence. The applicant is also then the person who has the right to receive the ashes after a cremation is carried out. We think that there is a problem with the law in this area. These problems arise because the law on who can apply for a cremation is not linked to the common law position, that's the law that's arisen through the development of case law, on who actually has a right to make decisions about a body after death. Currently, that person is generally the deceased person's personal representative, which is their executor or their presumptive administrator if they don't have a will. The upshot of that is that cremation law permits someone who doesn't have the legal right to make decisions about the body to apply to cremate it and then receive the ashes from the cremation. We've heard from a number of cremation managers that this situation results in disputes between the applicant and family members who would allege that the applicant never should have been permitted to cremate the relative in question. These are disputes that cremation managers tell us that they feel unequipped to resolve. Now, the third strand of the project that Nick described at the beginning of this event on rights and obligations will consider whether we should reform the law about who gets to make decisions about bodies. We consider that dealing with the question of who should be able to apply for cremation needs to come after we've answered that question as to who should have the rights to make those decisions. As a result, in the consultation paper, we restrict ourselves to asking you for your experiences of such problems as a result of the current state of the law. And we want to hear about those so that we can then inform decisions that we will make as part of the third strand. I'll touch then briefly on two other issues relating to the cremation process. One of those is in relation to unidentified bodies or body parts. In our pre-consultation discussions, the case was made to us that cremation should be avoided in relation to unidentified bodies or body parts. We think there's a good case for such a change on religious freedom grounds. Some faiths don't permit cremation, such as Islam and some forms of Judaism. Equally, some require it, such as Hinduism and Sikhism. If an unidentified body is cremated and the person is subsequently identified, nothing can be done if it transpires that the cremation was against their religious beliefs. In contrast, if they've been buried and it later transpires that they would have wanted to have been cremated, that can still be carried out. We also think that a requirement to take a DNA sample of any unidentified body or body part before burial should be put into law to solidify existing best practice and aid in the future identification of missing persons. We also make provisional proposals in relation to pacemakers removed by funeral directors. Pacemakers, along with some other medical implants, are required to be removed before a cremation because there's a risk that they may explode, causing damage to the equipment and potentially harm to those working at the crematorium. However, a specific issue arises in relation to pacemakers that have been removed. Due to Department of Health guidance from 1983, which only applies to pacemakers, not other implants, pacemakers may not, after death, be the property of the estate of the deceased person, whereas other medical implants are. And that means that funeral directors who remove such devices don't have the legal authority to dispose of them, meaning that they have, in many cases, built up a large collection of such items over the years since 1983. We think it's unlikely that the families of the deceased people for whom these devices were removed will want them back, but we propose a scheme which would require the funeral directors to post a notice giving a chance to reclaim them within a fixed period of time. If they do not, then we provisionally propose that funeral directors would have the power to dispose of them as they see fit. Moving away from the cremation process, I'll now turn to the question of where cremations can take place. At present, a crematorium must be constructed at least 200 yards away from any residential house, unless written consent has been given by the house's owner, lessee, and occupier. And they must also be constructed at least 50 yards away from a public highway. The distance to houses is a little shorter in London at 100 yards. This rule was introduced as an amendment to the Cremation Act 1902 by a backbench MP who was concerned about the impact of cremations on air quality, as well as the noise from the tolling of bells. While sensitivities on air quality continue to exist, modern pollution abatement technology means that rule appears to have outlived its intended purpose, and there's not so much concern about the noise from tolling of bells in general, I think, anymore. But the rule now has other effects. Firstly, it can impact on where planning permission is given for crematoria to be built. In some cases, the rule is cited as a reason for granting permission to build a crematorium on greenbelt or other countryside land, when otherwise development wouldn't be permitted. Secondly, and relatedly, the rule could be argued to preserve the solemnity and quiet of crematorium sites, where the rule was originally intended to protect the outside world from crematoria. Arguably, it now operates to protect crematoria from the outside world. There are arguments, though, for abolishing the rule. There's no such requirement that burial grounds are built away from homes or highways, even though they are similarly sites of mourning. Prohibition on homes being built within 200 yards of a crematoria once it has been built, which somewhat undermines the effect of the rule. And we've also heard that one of the effects of the rule is to restrict the development of new crematoria, which may affect whether the demand for cremation services in different parts of the country is met. Because the arguments on both sides are complex and balanced, we consult mutually, asking consultees whether they think the rule should be retained or repealed, and for their reasons why. We also ask some technical questions on the measurement of the relevant distances and on the enforcement of the rule. I'm now going to hand over to Abby to talk to us about the treatment of ashes after collection from crematoria.
So finally, I'll turn to the question of what happens to ashes after they've been collected from crematoria. The two main issues here relate to uncollected ashes held by funeral directors and the status of buried ashes. So for uncollected ashes, often when a cremation takes place, the applicant will instruct the crematorium to return the ashes to the funeral director for collection. They're not always then collected. This is for a variety of reasons, such as the applicant may themselves die or become unable to collect them. There might be a dispute as to who should collect them, or the difficult relationships that grief can exacerbate may mean that they don't wish to. We understand from the National Association of Funeral Directors that over 250,000 sets of ashes remain uncollected. Crematoria have powers under the 2008 cremation regulations to bury or scatter ashes once they have given the applicant 14 days notice of their intention to do so, but funeral directors have no such powers, and crematoria are under no duty to take back uncollected ashes. These ashes pose a storage problem for funeral directors, but moreover, we understand that funeral directors are uncomfortable with their offices being the final resting place of these remains. We provisionally propose that to resolve this situation, funeral directors should be given a right to return ashes to the crematorium where the cremation took place, and the crematorium should have a consequent duty to accept them. The crematorium would then be able to scatter or bury them in line with the current law, that is, after giving the applicant 14 days' notice. Before funeral directors can return ashes, under our provisional proposals, they would have to take reasonable steps to ascertain the applicant's wishes. Then, if no response is received within 4 weeks, they should have the right to return them. A similar scheme was introduced into Scots law in 2016. However, that law doesn't have retrospective effect, whereas the reform that we're proposing would have retrospective effect, meaning it would apply to the large number of ashes that are currently being held by funeral directors. We acknowledge that this will likely result in potentially significant new costs on cremation authorities relating to making contact with families and also finding the space to scatter or bury the ashes that are returned to them. And to some extent, this would be temporary while the current problem is resolved, and reform would prevent such a problem arising again in the future. However, the practical difficulties in dealing with the legacy of uncollected ashes has been raised with us, and we are interested in hearing about possible solutions that you might be able to suggest. The second issue relates to buried ashes. Currently, when ashes are buried, just as with a body, a licence or faculty is required to exhume them. On a strict interpretation of the law, this would seem to apply in all cases, including when ashes are buried without a container, or indeed when they are strewn, that is, poured onto the ground before being covered with earth. Strewing rather than scattering is a requirement in Church of England and Catholic theology. We don't consider that there is a problem with requiring an exhumation licence for ashes that are interred in a container in the ground. but the purpose of requiring a licence for ashes that are not held in a container is questionable. We've heard that interred ashes which are not in a container can remain in a single identifiable mass in the ground, but this isn't always the case. We think that in such cases, applying the offence of unlawfully exhuming remains may be difficult. We think that there are two principles that could be used to determine whether or not ashes should be included within the exhumation offence. These are whether the ashes are identifiable, meaning that they are separable from the earth and that their location within a plot of land can be identified, and that those who interred the ashes intended that they would remain identifiable. However, we recognise that reforming the law based on this has its drawbacks. For example, it's speculative, as a person might not know whether or not a particular set of ashes are actually identifiable until they've begun to unearth them. As a result, we consult between that approach and a pragmatic approach of requiring an exhumation licence or faculty where ashes are interned in a container or where they are interred in land where an exclusive burial right exists. And finally, just want to mention the issues we haven't had time to cover today. As you'll see on screen, this slide's just a brief note of the topics that are covered in our consultation paper, but that we've not had time to discuss today. We also ask a number of questions at the end of our consultation paper on the potential impact of our proposals. So I'd just like to say, on behalf of the team, thank you very much for your contributions and participation today. And the consultation period is running until the 9th of January, so please submit your written responses using our online response platform. But of course, if you can't use that, please submit them by email or post. Your responses will enable us to make final recommendations that reflect the expertise of those who work in the sector and also the real life experiences of those who've had experience, whether through friends or relatives who've had funerals. So thank you very much, and I'll hand you back over for the final Q&A session.
Thanks very much, Abby. So we'll pick up the questions from the one posted by Chris Pilkington that appears as town clerk, who asks whether private cemetery operators includes public bodies which are not local authorities, for example, the NHS. And I think the answer to that is yes, it is a broad category. Burial grounds aren't controlled by local authorities or the Church of England, sort of generally fall within the broad category that we describe as private.
I would maybe just add that it's possible that in specific circumstances there may be something in a private act of Parliament applying to a particular development that might govern it as well. So you know, our assertions that there's no laws applying in relation to such cemeteries may or may not be true in the case of that individual cemetery, but yeah, generally any sort of cemeteries operated by other public institutions would fall within that group.
Yep, thanks, Andrew. Then a question from Michael Kerrigan, who asks what requirements there would be on crematoria to computerise records of ashes that are returned to them that date from a period prior to computerisation. We don't explore that in the consultation paper. We don't generally explore the sort of the operational angle of the proposal, but we would be very keen to hear of any sort of potential difficulties you foresee. I mean, under our provisional proposals, there wouldn't be a requirement for the crematoria to computerise the records. So it would be a matter for the crematorium to decide how it was going to sort of keep those records. Mary Jane asks if we are considering open air cremations in specially constructed crematoria following the Devinder Guy case. We do discuss that case in the consultation paper. We don't ask any questions on it. Our understanding is that it is possible as a result, it is possible for a crematorium to be constructed that would fulfill the requirements of those faiths that require sort of light to be on the body, but that none have so far been constructed. Tamara Galloway comments that uncollected ashes should be interred rather than scattered in case somebody later comes forward to collect them. Our provisional proposal in that respect is based on existing powers that crematoria have, which is to scatter them. There is a current requirement that they are interred, and I think it is hoped that the safeguards in place in terms of contacting family would sort of ensure that there's an opportunity for them to be collected, and you know, the family would be aware that if they're not, then they would be scattered rather than interred. So it is a final chance to collect those ashes. Then a question from John Pitchers: what type of samples from DNA are being proposed in relation to unidentified people who would collect and store samples? And again, at this stage, our consultation question is based on was asking about the principle of that DNA being stored. We haven't sort of gone into the operational details of how that would be done and how that would be stored. I think those are matters that, if the principle is one that is supported, those are matters that would then be explored. I'll hand back to Andrew at that point if there's anything further you want to add.
I just note on the DNA samples point, in terms of who might hold such a sample, there is a UK missing persons database operated by the NCA, I believe, and we do sort of point to that as a potential option for storing that that data. I think it's operated by the NCA. I might be incorrect on that. Apologies if so. And the last question that we've got there is Jocelyn Greenway asking, could we resend the link to the consultation along with the slides? Yes, we will include the link as we send the slides out to attendees. Yes.
Thank you. And with that, I think we can bring this event to an end. Just reiterate the thanks that Abby gave you at the end of the talk there to you all for attending this session. We hope you have found it useful and that it will prompt you to send in a consultation response. So thank you very much, and we will bring this event to an end now. Thank you.